Today I will tell you about law courts and the constitution. India's commitment to the rule of law is grounded in the constitution which established India as a sovereign socialist secular democratic republic with a parliamentary form of government. The Constitution of India is the supreme legal authority which binds the legislative, executive, and judicial organs of government. The Constitution grants all citizens fundamental rights and empowers the independent judiciary to invalidate legislation of all government action which violate the Constitution. Some of the other key features of the Constitution are a federal system or of governance between the union and the states, separation of powers between the three organs of the government, free and fair election, equality before the law, and a secular state that recognizes freedom of conscience and religion. Source of law. The Constitution of India is the source of legal authority and empowers Parliament and the legislatures of states and union territories to enact statutes. There is also a vast body of laws known as subordinate legislation in the form of rules, regulations, and bylaws made by central and state governments and local authorities like municipal corporation, municipalities, gram panchayats, and other local bodies. This subordinate legislation is made under the authority conferred or delegated either by Parliament or the concerned legislature of the state or union territory. The decisions of the Supreme Court are binding on all courts within the territory of India. As India is a land of diversities, local customs and conventions which don't contradict a statute of the Constitution are recognized and taken into account by courts while administering justice in certain spheres. And enactment of laws. The seventh schedule of the Constitution contains three lists: a union list, a state list, and a concurrent list. These lists set out the various subjects on which Parliament and state legislatures are empowered to make laws. The Indian Parliament is competent to make laws on matters enumerated in the Union list. State legislatures are competent to make laws on matters enumerated in the state list, while both the Union and the states have the power to legislate on matters enumerated in the concurrent list. Only Parliament has power to make laws on matters not included in the state list or the concurrent. In the event of repugnancy, laws made by Parliament shall prevail. Other laws made by state legislatures to the extent of the repugnancy. The state law shall be void unless it has received the assent of the President, and in such case shall prevail in that state. Applicability of laws. Laws made by Parliament may extend throughout or in any part of the territory of India, and those made by state legislatures generally apply on within the territory of the state concerned. Hence, variations are likely to exist from state to state in provision of law relating to matters falling in the state and concurrent list. Judiciary. One of the unique features of the Indian Constitution is that now, withstanding the adoption of a federal system and extension of union and state acts in their respective spheres, it provides for a single integrated system of courts to administration both union and state laws. At the apex of the entire judicial system is the Supreme Court of India, followed by the High Court in each state or group of states. Under the administration of each High Court are the district courts, village panchayat court also function in some states under various names like Nyaya Panchayat, Gram Nyayalaya, Gram Kacheri to decide civil and criminal dispute of petty and local natures.